So what do you do if you already have a judgment lien against you and you need to file bankruptcy? Will bankruptcy get rid of it if there's already a judgment? Watch our next video and find out. So judgment liens are a very important part of bankruptcy cases in that what we see a lot of folks miss these in terms of listing them correctly and also getting rid of them in the bankruptcy. So what does that mean? Well, in a Chapter 7 case, if you have a lien against you, a judgment lien against you, there is a motion that we can file. It's called a motion to avoid judicial lien. And depending on the equity in your property, we can usually get rid of those liens. They'll be treated as an unsecured debt and they will go with the wash, so to speak, when your case is discharged. Now, it is very important that you let your attorney know that you have a judgment lien, because if you don't tell us, and sometimes credit reports are not always the most effective way to look at debts and liens. I wish they were, but they always have errors. You need to make sure that you're letting your attorney know if you've been served a lawsuit, if you've been notified that you have a judgment, just so they can check to see if it's really there. The process is actually very simple. It's a motion, and then there's an order entered, but you have to make sure that you're aware of what's out there. If it's not, if you go through, say you go through a Chapter 7 and the lien is not avoided, well, guess what? The lien is still alive, and that creditor can actually collect on the lien because it is still there. So avoiding liens is very key. Now, the other kind of lien that we see in bankruptcy is we will see a lien on items. So say you pledged, you went to a World Finance or All-Time Finance, something like that, and you pledged collateral for the loan. So it wasn't the collateral that you actually purchased with the money, but it was just, usually it's your TV, your microwave, your computer. Those are kind of common items that they'll have you sign. So we can avoid a lien on that as well. However, you need to make sure you let your attorney know if this loan that you took out actually has items pledged for it. Again, it's something that most attorneys I know, we don't charge extra for it. It's just part of the process, but you need to let us know. And the same thing is going to apply in a Chapter 13 case. If you have a judgment, we need to be able to know about it, be able to file the motion to avoid the lien, so that that debt will then be moved over from being a secured debt, which is one that's going to have to be paid through the case, to one that may not have to be paid through the case, which is an unsecured debt. So for a lot of our clients in Chapter 13, they're not repaying all of their unsecured debt. So if you have a $50,000 judgment and we can do a motion to avoid it, it goes from something that you would have to pay now to an unsecured debt that you're not going to have to pay anything on. So it's very key. So again, if you have any questions about this video or any of the topics, always feel free to shoot us an email. Our information is down in the description, and we're happy to answer any questions.